Okay, committee, we'll call to order. We'll dispense with a prayer and move on to review and adoption of the agenda. Any additions, deletions? No? Agreed? Okay. Declarations of conflict of interest? No. Hearing none? All right. If you can bring members, our witnesses and members of the public in.
Sick.
Pardon me?
You're sick?
No.
I'm sick. I didn't see anyone from them.
They were going to come?
I think so.
Okay. Yes, yeah, that's fine. Thank you, Mr. Dent. Welcome this evening to Standing Committee on Government Operations public hearing on Bill 30, an act to amend the Human Rights Act. We'll begin with members introducing themselves to the record, starting with Mr. Simpson.
Good evening, R.J. Simpson, MLA for Hay River North.
Good evening, Danny McNeely, Satu.
Welcome, Michael Natalie, MLA for Ditchell.
And I am Kieran Testard, the member for Camp Lake and chair of the Standing Committee on Government Operations. And with me at the table are April Taylor, our committee research advisor, and Jennifer Franki-Smith, committee clerk. The Standing Committee on Government Operations is a committee of regular members of the Legislative Assembly. The bill we are reviewing today was introduced by the government, given first and second reading in the Legislative Assembly, and then referred to the Standing Committee for review. This is the final of 4 consultations that the Standing Committee held in Fort Smith, Inuvik, Fort McPherson, and tonight here in Yellowknife. Before we report back to the Assembly on the proposed legislation during the current February-March sitting, which started today. It is our responsibility as a standing committee to consult with residents of the NWT on what they like or don't like about the bill. We would like to hear your views and comments, which will be used by the committee to identify any changes we would like to see made to the current bill, and which we will then report back to our colleagues in the Assembly. Seeing that there's not a preponderance of members of the public, I won't get into the exact nature of the bill because I think our witnesses are well aware of it, but there are copies of the bill at the side table there, and they are available online if anyone is watching at home. If you'd like to share your views with us today, please let our clerk know, and they'll make sure to get you on the list. We'll also accept written submissions by post or email until Friday, February 8th, 2019 at 5 p.m. One final piece of housekeeping, please remember that all submissions will be part of the official committee records and may be reflected in our final report. Any submissions made during this meeting may also be televised or broadcast via social media. Thank you again, everyone, for your patience in allowing this introduction. With members' agreement, we can now open the floor to comments from our witnesses. Mr. Simpson?
Thank you, Mr. Chair. I know that we don't have a lot of people physically in the room right now, but there are people watching online. Perhaps we can do what we did when we visited communities and go over some of the brief points just so people have an idea of what this act is actually amending.
Yeah.
A list right here if you'd like them.
Yeah. Thank you.
Thanks.
All right. Thank you, Mr. Simpson. So we will, at the committee's request, we will go into the components of the bill. Bill 30 is an act to amend the Human Rights Act and has been referred to the Standing Committee on Government Operations for review. The bill proposes to bring the amendments into force annually over a 3-year period, consolidate the Office of the Human Rights Commission and Office of the Director of Human Rights into a single agency called the Human Rights Commission, clarify the public interest mandate of the Commission, provide that restorative principles are to be applied to human rights protections and processes in the Northwest Territories, make changes to the operation of the adjudication panel, add gender expression as a prohibited ground of discrimination, and adjust the terminology in the French version related to gender identity and make other minor wording amendments for clarity. So the first of the bill's many features, the first section is that the act should be let me get to the right section. So the first feature of the bill is to bring the amendments into force over a 3-year period. So this means that the bill will be gradually changed from the period of 2019 to 2021. So this staggered approach allows the Commission and members of the public who are accessing human rights concerns through the Commission to have those new sections gradually roll out. Consolidating the Office of the Human Rights Commission and the Office of the Director of Human Rights into a single agency. This bill realigns the roles of the Executive Director and the newly consolidated Commission. The rationale we have received from the government is to simplify the system for stakeholders and improve the efficiency of the agency's work. Responsibility for protection and promotion activities will remain with the Commission. The investigative, resolutive, and administrative roles will remain with the Commission. The Commission will assume the roles of deferring, dismissing, or referring complaints to adjudication. The Director will serve as Executive Director and report to the Commission, on which he or she will serve as a non-voting member. This approach also engages Commission members directly in assessing complaints under the Act. Previously, the human rights regime was split into 3 very distinct portions: the Office of the Director, the Commission, and finally the Adjudication Panel. And this brings 2 of those bodies together, the Director and the Commission, and harmonizes their functions. So it is the appointed members of the Commission who are reviewing some of these investigative, resolution, and administrative roles. And this structure would appear to make more sense in the day-to-day operations of how the Commission works to review and assess human rights complaints. And the Human Rights Commission will continue its work in promoting its mandate and promoting its work to make Northerners aware of their human rights under the Act. The third purpose of the bill is to clarify the public interest mandate of the Commission. These clauses amend the start of the bill, that is the responsibility of the Commission to protect the public interest, and that the functions of the Commission set out in the bill are exercised consistent with that responsibility. And this also allows the Executive Director position the responsibility of carriage of complaints. So the Executive Director has carriage of complaints before the Adjudication Panel, and that the Executive Director requires written permission from the Commission before having carriage of a complaint before the courts, and provides for greater clarity that the Executive Director has carriage of complaints for the purpose of representing the public interest and upholding the Act. So that means if someone brings a complaint forward, it's the Executive Director who carries that complaint forward into the Adjudication Panel and potentially into court action if that's required. The fourth purpose of the bill is to provide that restorative principles are to be applied to human rights protections and processes in the Northwest Territories. And this part of the bill just reflects the fact that the Human Rights Commission has found that a restorative approach tends to work better than a adversarial approach that you would see in a courtroom, for example. And the restorative approach will now be cemented in legislation. It was the practice of the Commission, and they find it results in better judgments and better results for those with human rights complaints. And I'm sure we'll hear more of that from our witnesses from the Human Rights Commission in how that works. The fifth part of the bill is to make changes to the operation of the Adjudication Panel. And this will allow the Adjudication Panel to use processes for pre-hearing conferences that are consistent with a restorative approach to dispute resolution, and amends certain sections of the Act which sets up the contents of a remedial order that may be issued by an adjudicator to allow adjudicators to order broad systemic remedies. And the final significant section of the bill is to add gender expression as a prohibited ground of discrimination. And this will add a new a new ground that you cannot discriminate against, which is how someone chooses to express their gender in the Northwest Territories. So that is the government's bill in a nutshell. Our work to date has been to hear from Northerners on their perspective on how this legislation affects them and their communities, and whether or not we can find areas of the bill that can be improved and seek those changes as a standing committee of the Legislative Assembly. So without, unless there's anything further, anything I missed? Nope, no problem. And thank you for reminding me. We find that our consultations can always be tweaked a bit to give people more information, and we do know that there are those watching at home. So thank you for that reminder, and thank you for your time. And without further ado, I'll turn the floor over to Mr. Charles Dent, who is Chair of the Human Rights Commission. If you could introduce yourself and anyone you have with you, and proceed with any presentation or comments you have.
Okay, thank you, Mr. Chairman. I'd like to thank you and the committee for this opportunity to address the amendments to the NWT Human Rights Act, which are brought forward in Bill 30. With me this evening is the Director of the Human Rights System, Ms. Deborah McLeod. I'm grateful to be able to meet with you on the traditional lands of the Yellowknife's Dene, First Nation in Chief Draigie's territory. I would also like to acknowledge that the Commission works in the traditional territories of the Dene, Inuvialuit, and Métis people, and recognizes its obligations under Treaties 8 and 11. Mr. Chairman, the amendments proposed in Bill 30 stem from an independent comprehensive review of the NWT Human Rights System contracted by the NWT Human Rights Commission in 2014. As that was the 10-year anniversary of the implementation of the NWT Human Rights Act, the Commission thought it timely to review how the legislation and structures created by the Act were performing. We wanted to look at what progress they had made in helping achieve the original purpose and potential of the Human Rights Act. The three independent agencies created by the current Act, the Commission, the Adjudication Panel, and the Director, accepted the findings from the review. Representatives of the three agencies had previously formed a working group, which, after review of the report, developed an implementation plan for the recommendations contained in it. The implementation plan, called Moving Forward, was tabled in the Legislative Assembly in September of 2015. All three human rights agencies, again through the working group, also began working with the staff of the Legislative Assembly and the Department of Justice on the amendments to the NWT Human Rights Act recommended in the comprehensive review. I'd like to take this opportunity to thank the staff of the Legislative Assembly and the Department of Justice for their hard work and collaborative manner, which ensured the spirit and intent of the changes recommended by the comprehensive review came to fruition in the suggested amendments to the Act. A major recommendation of the review report was that the human rights system adopt a more restorative approach in the human rights complaints process. The original intent of the NWT Human Rights Act was to have an accessible service where people could come to talk about their human rights concerns and have them addressed. The review report found the process was over-legalized, making it ineffective and inaccessible for most people. It found that unrepresented complainants had a serious barrier to access to justice in a legal process focused on procedure and precedent and using unfamiliar language. This was not something new to the three independent agencies that currently make up the NWT Human Rights System. In fact, it's something the working group had discussed and that had been identified in annual reports to the Legislative Assembly from the Commission. However, it was important that the problems were identified through the independent review process. The human rights complaints process in the NWT had developed to be adversarial in nature. To counter that, the review report recommends the adoption of a restorative approach to dispute resolution. A restorative approach focuses on resolving disputes while maintaining, and repairing relationships. It fosters a sense of social responsibility and shared accountability. A restorative approach considers the whole context of the issue. It encourages those involved to work out solutions together rather than assigning blame. The amendments in Bill 30 provide that restorative principles are to be applied throughout the NWT human rights system, both in ensuring compliance with the Act and in promoting respect for and observance of human rights. We have not waited for the change in legislation to begin implementing restorative approaches in the complaints process. and are already seeing positive results. The amendments resulting from enacting Bill 30 will assist us to change our processes even further. The review report also recommended significant changes in the structure and responsibilities of the Commission. The amendments in Bill 30 consolidate the Human Rights Commission and the Office of the Director of Human Rights into a single agency called the Human Rights Commission. Both are currently independent agencies. The change in structure and the more direct role of the Commission with respect to the handling of individual complaints will increase its information and knowledge in this area and enable it to better fulfill its public interest mandate regarding protection, promotion, and education on human rights. The amendments will also clarify the public interest mandate of the Commission in terms of the explicit nature of the Human Rights Commission's responsibility to protect the public interest. In addition, the amendments will expand remedial options, allowing adjudicators to order remedies to promote compliance with the Act, including with respect to future practices. The review report found the threshold for referral of complaints to the adjudication panel for hearing is too low to allow for proper screening of complaints. The amendments in Bill 30 will raise the threshold for referral of cases to hearing, allowing the Commission to dismiss cases where they find the complaint is without merit, raises no significant issues of discrimination, or there is no reasonable likelihood that further investigation will reveal evidence of discrimination. The amendments in Bill 30 provide for the carriage of complaints at hearing by the Commission in recognition of its public interest mandate. Carriage will be of particular assistance in situations where there are unrepresented parties at hearing. Enacting Bill 30 will give adjudicators the ability to use practices and procedures different from those in the traditional adversarial process. This is another important part of making the system more accessible to unrepresented parties. The amendments in Bill 30 add gender expression as a prohibited ground of discrimination. This expands and clarifies the grounds of sexual orientation and gender identity that are already present in the Act. Although it's not addressed in the review report, the Commission previously brought forward the grounds of genetic discrimination and unrelated criminal conviction as additional grounds to be included in the Act. The Commission would like to see these grounds added as an amendment to Bill 30 if there is agreement to do so. However, we would not like to see Bill 30 held up for these amendments. Ensuring we can move forward to a more restorative process should not be delayed. The addition of these grounds could be considered at a later time. Thank you to you and the committee, Mr. Chairman, for this opportunity to speak this evening. If you have any questions, we'll do our best to answer them.
Thank you, Mr. Dent. Mr. Nakamag has joined us. If you could introduce yourself for the record.
Hi, good evening. Sorry, it's a bit late. I had a conference call. Herb Nakamag from the NACPIT. Welcome.
Thank you. Committee, I'll now invite members to ask questions to our witnesses. Mr. Simpson.
Thank you, and thank you to the witnesses. And I appreciate the work that has been put into this by the Commission. I know that much of this Act is based on the report, and I just want to clarify the Commission's role in the development of this legislation. As it was being drafted, was the Commission shown drafts along the way, and did the Commission have the ability to give input to the Department while drafting the legislation? Thank you, Mr. Chair.
Thank you, Mr. Chairman. Yes, it was a very collaborative approach. The Commission and representatives of the working group met with representatives from both the Department of Justice and the Legislative Assembly to talk about the process and moving it forward.
Mr. Simpson.
Yeah, thank you very much. I just wanted to be sure that you're familiar with the actual language in the Act, and this is something that I brought up before. You were before us when we had the review of the annual report, and it was either then or we went in camera to discuss it, and I brought up one of the proposed amendments, and it's proposing paragraph 62.3, and that's the paragraph that talks about the powers of an adjudicator. And as it sits right now, the adjudicator, if the panel finds that someone has contravened the Act, they have quite extensive powers to take steps to either take punitive measures or to put the person, whose rights were violated in the position they would have been otherwise in terms of employment and in terms of money. They also have the power to make an order to refrain in the future from committing the same or similar contraventions, and may make a declaratory order that the conduct complained of or similar conduct is discrimination contrary to the Act. And so it seems to me that if the Act is contravened by an entity, there's plenty of power in place to ensure that that conduct is chastised, and there's things in place that ensure that conduct won't occur again, and if it does, it's automatically in contravention. And so I wonder what the rationale is behind adding Clause 24, which would add another subparagraph under 62.3a, and that is giving the adjudication panel the power to do anything the adjudicator considers that the party ought to do to promote compliance with this Act, including with respect to future practices. And the reason I bring that up is because it's not talking about compliance with the part of the Act that was contravened. It's talking about compliance with the entire Act in general, and it's not something that the person has already contravened. It's something that the adjudication panels thinks they may contravene. And so it's sort of reminiscent of dystopian future novels where we have people being convicted of pre-crimes or being charged for things they haven't done. And so I was wondering, what is the rationale for including this, already given that there is such powerful remedies at hand for the adjudication panel as it is? Thank you, Mr. Chair.
Mr. Dent.
Thanks, Mr. Chairman. But the Act is, as it is written right now, is fairly prescriptive as to what an adjudicator can order. It's not as broad as it might appear on its face. So, for instance, if an adjudicator were to order that a policy be changed or a company develop a policy to make sure that discrimination that is exactly the same as what has occurred doesn't happen again, that's not something they can do right now with the current Act. That's why they need this amendment in to bring it. So. The Commission does support this amendment. It echoes similar provisions in several provincial jurisdictions, including Ontario, Saskatchewan, Manitoba, and Nova Scotia. The provision allows adjudicators to order education, changes in policy, as I mentioned, that have been found to be discriminatory. So if they've got a policy that's in place right now that's discriminatory, they would need this legislation as it is in Bill 30 in order to order that policy be changed. So this goes a bit beyond Mr. Simpson's right. The current situation now, which really only allows simple financial or other compensations to the individual complainant. This amendment will give greater protection to the public interest in systemic issues, because we're one of the biggest things that came out of the review report, the comprehensive review, was that the Commission should focus much more on systemic issues. And without having some way to cause some sort of systemic I've lost the word, but without being able to enforce a systemic remedy, it reduces our ability to actually get involved in those systemic areas. So, as an example, in Nova Scotia, Sobeys was ordered to offer training to all their employees in the area of racial profiling. So because one complaint came forward about racial profiling, the adjudicator was able to say, you need to make sure that all your employees don't enter into racial profiling in your stores. And so, working with the Nova Scotia Human Rights Commission, there was a online training program that was developed. It can be done in less than an hour. And so far, over 12,000 people have taken that training in Nova Scotia. And Sobeys was so impressed with that course that they asked if all of their employees in Canada could take it. And have got the Retail Council of Canada involved to support that. So Nova Scotia brought the idea to CASHRA, the Canadian Association of Statutory Human Rights Agencies, and now through our website, all of Canada can take part in that training for free. So, it isn't intended to be necessarily something that is onerous. I mean, our mandate is education, and we want to be able to work with people to make sure that education is the solution to particularly systemic issues. But if there isn't some way to get employers involved in participating in that education, then we're still on the outside sort of trying to bring that education to bear.
Thank you, Mr. Dent. Mr. Simpson.
Thank you, and I agree that the commission should be much more involved and with the focus on education. I'm talking about the powers of the adjudication panel. And, you know, the example you brought up, yes, the initial, what sparked the training was the adjudication panel, but there was voluntary training across Canada through an education program. Right? It wasn't ordered across Canada that people take this training, yet they voluntarily took it. And you stated that this is needed in order to make an order that a policy be changed. Well, there's already the power to make an order saying that that policy is in contravention of the Act. And so I don't know how why people would be following a policy that is already found to be in contravention of the Act. I guess my concern here is that it is such a broad power, and it's reminiscent of some of the issues that have come up with the powers given to WSCC, you know, in the last assembly. And I've heard a lot of people concerned about that the concern is that we make these laws and we give these organizations this power, and it can result in a lot of overreach. I mean, you know, you made a good point about what happened with Sobeys, but the vast majority of violations of human rights, you know, under the Act are accidental. They're done through ignorance, and, you know, all it takes is a little bit of education from the Commission. But what this could result in is an adjudication panel saying that, you know, this mom and pop organization that violated this person's human rights now has to take training, 2 days of training, and all the new employees have to take 2 days of training. And what if that organization is based in Tuck and all the training is in Yellowknife? I mean, you could be looking at tens of thousands of dollars, which would be enough to put someone out of business. But that's the power that we're giving them here. And I'm not saying that this adjudication panel would do that, but we can't rely on the reasonableness of adjudication panels. We have to enshrine this stuff in legislation. So I know I've hammered this with the committee, and I brought this up with the Commission already, so I won't go on about it, but I just wanted to put that out there, that we as legislators need to consider the potential of the legislation that we create. Thank you, Mr. Chair. Nothing further.
Thank you, Mr. Simpson. Mr. Dent, would you like to respond?
You know, coming from the private business sector, I understand where Mr. Simpson is coming from. I've always owned and operated businesses in the Northwest Territories for the last 40 years. So I'm sensitive to that issue. But I think when you look at Section 62 right now, it's really focused on the individual. And for the Commission to get past that and get into systemic issues, we need to be able to have the adjudicators be able to make systemic orders for remedy. And I would hope that, you know, the penalties that can be awarded by the adjudication panel are fairly steep. So I think argue that the possibility to take training will probably reduce the likelihood of further fines, which can be in the tens of thousands of dollars as well. So I think it's important to recognize that, you know, the Commission has an obligation to work at education. I don't, you know, I think that what we want to do is make sure that that there's an opportunity for the adjudication panel to ensure that we have a partnership with the business community to make sure that education can be delivered.
Thank you, Mr. Dent. Mr. Simpson, you had something further?
Thank you for indulging me with my follow-up, and I'll give the Commission a chance to convince me. Could I get some specific examples in the Northwest Territories of what kind of injustices have been committed because the legislation lacked this particular provision? Thank you, Mr. Chair.
Mr. Dent?
There was one case in which the adjudicator did order education, and the respondent went to court to say that wasn't included in the legislation, so they couldn't order it. And they were successful at that argument because the legislation doesn't include it. This was, I'm not sure if I should say any more, actually, I'm not.
Okay, thank you, Mr. Dent. And we appreciate your willingness to indulge the member's question, but certainly within reason of your whatever confidences you need to keep with the commission. Mr. Simpson?
Thank you, and I'll just once again, I'll bookmark my comments by saying that there are a lot of good stuff in here, and I appreciate the work the commission has done, and I'll have some comments about another topic, but I'll cede the floor to other members. Thank you.
Thank you, Mr. Simpson. Mr. McNeely?
Thank you, Mr. Chair. My question there is, what sort of things happened after the implementation plan was tabled? I noted in your presentation that there was a document called Moving Forward that was tabled by the previous assembly in September 2015. I haven't read that implementation plan, but was there some meaningful provisions that was implemented out of the implementation plan, not knowing whether they could fit in with the regulatory administrative change or recommendations coming to the amendment of the Act? Thank you, Mr. Chair.
Mr. Dent?
Thank you, Mr. Chairman. There was no response from the government in terms of making changes to the legislation as a result of the implementation, or the proposal that was tabled for implementation. What we basically developed, the working group developed this implementation plan, presented it to the Legislative Assembly and said, here's what we recommend the process be to go forward with implementing the recommended changes. And the response really was, okay, then let's take a look, let's start a discussion about what we should do to change the legislation, and what you're seeing as a result is Bill 30. So that is the response to the implementation plan.
Thank you, Mr. Dent. Mr. McNeely?
Yeah, thank you, Mr. Chair, and thanks for that reply. That was going to be my next question, was what types of implementation or suggestions, recommendations that are included in today's amendment. That was going to be my second question, but you answered that. So I see some meaningful dialogue happen and some meaningful work came out of the implementation plan, which is sitting in front of us today. So it wasn't a waste of time. So thank you.
Thank you, Mr. McNeely. Mr. Simpson?
Thank you. I wanted to talk about genetic discrimination being considered as a possible ground. I think it's a ground, yeah, ground. You mentioned that this was in the report and this was recommended to the government to include in the legislation? No? Oh, sorry, my mistake here. I was in the middle of something else.
Mr. Dent would like to clarify.
Yeah.
Mr. Dent?
Perhaps I can clarify. The genetic discrimination issue was not included in the comprehensive review, but it is something that the Commission itself has proposed as a ground that should be included in the legislation through our previous annual reports. So it's something that has been recommended in the past. It was not included in this legislation. And as I say in my opening comments, we still believe that it's something that we should be moving forward with. The federal government has now implemented this as a ground. But we think it's more important to make sure that we can proceed with achieving the full restorative process than slowing this down. So if it's necessary to get the amendments to the grounds later, we're happy to see that happen. We want to see the restorative process implemented for sure, so we'd like to see this bill go forward in a timely manner.
Thank you, Mr. Dent. Mr. Simpson?
Thank you very much. And so I assume that you said you had discussions with Justice along the way, while this was being drafted. And so were you given a rationale as to why that is not included in the legislation? Thank you, Mr. Chair.
Mr. Dent?
I think at the time we first started this process with Justice and the Legislative Assembly, if memory serves me correctly, there were no jurisdictions in Canada that had adopted genetic discrimination. So it's a fairly new idea, and I think if memory serves, it was more of a let's wait and see how this plays out across Canada.
Mr. Simpson? And I'll remind everyone that Mr. Dent collaborated on the bill but did not ultimately draft it. So some of these questions might be best asked to the Minister of Justice, but you may continue.
Oh, yeah, no, I was just wondering if he was given a rationale, and I appreciate that, and I will be asking the Minister of Justice because it's a pretty thin rationale if that's what they're standing on, that no one else has done it, so we're not going to do it. Because I know that the Human Rights Commission has done some cutting-edge stuff, and so it would have been nice to see this in there. Nothing further on this right now. Thank you, Mr. Chair.
Mr. McNeely?
Thank you, Mr. Chair. I noticed in your second paragraph to your presentation, you had mentioned that you work closely with these First Nation groups. And I recall some experiences that I had with Gladue reports. Is there a position that you encountered in your dialogue with the organizations, as mentioned here, in the area of suggesting legislation to the Gladue reports, or a mandatory report that could be in protection of the human rights of the individuals, the Indigenous individuals in our territory? Thank you, Mr. Chair.
Mr. Dent?
Thank you, Mr. Chairman. If I could just get or seek some clarification from Mr. McNeely. Are you referring to using Gladue reports in human rights hearings, or are you talking about seeing Gladue reports as a human right, and therefore something that the Commission should be paying attention to with the courts?
Mr. McNeely?
Yeah, thank you, Mr. Chair. That's your second your second view is my question. Having human rights to the Native Indigenous individual to see a Gladue report accompanying their rights for the incarceration that they're going through. It seems that we're lacking in that area in the territories. I think I may have brought that up several times, but it doesn't seem to go anyplace. So I'm just wondering if the Gladue reports are really a neglect in the human rights of the Indigenous community in our territory. Is that something that the Commission discussed with the individuals mentioned in the presentation here? Thank you, Mr. Chair.
Mr. Dent?
Thank you, Mr. Chairman. I haven't personally discussed them. I know I attended the Dene National Assembly last year, and I've met well in Nunavik with Mr. Smith, but this issue hasn't come up at all in those conversations. And it may be because our Act really doesn't give us a ground with which we could work with that. I mean, other than using moral suasion, we don't have the teeth in the Act to really get involved in that area that I can see. But I would certainly be sensitive to a discussion, and we're always willing to work with community partners to try and move human rights forward.
Mr. McNeely?
Yeah, thank you, Mr. Chair, and thanks the Commissioner for that reply. That was going to be my next question, is if there is some exploration we can look into, or your Commission could look into as a Gladue right in the Human Commission or the Human Rights Commission sector, whether it's appropriate to have the Gladue reports as part of this implementation plan or part of the amendment. I'm not really familiar in the whole legal process of this act, and the applicable nature of Gladue. But if you're willing to do some work in that area to see if it qualifies, I'd be glad to hear your outcome. Thank you, Mr. Chair.
Thank you, Mr. McNeely. I'm not sure if that's in your remit, Mr. Dent, but if you would
It's,
provide a response.
no, it's a tough question. And not being a lawyer myself, it's a situation I'm a little uncomfortable trying to give an opinion, but my guess is that really it's the Legislative Assembly that determines whether or not, or what grounds should be in our act, and then it's the Commission that takes those grounds and moves them forward, or make sure that they're enforced. So it isn't something where the Human Rights Commission itself can't look at something and say this should be there. It's like the genetic discrimination question that Mr. Simpson was asking. We have to wait for the Legislative Assembly to tell us that that's a ground before we can actually make it work. So it would be the same thing with Gladue reports, but since that's the courts, I'm not sure that we would even be able to intervene there. I suspect that the courts would be totally independent from our work, because if somebody isn't happy with our work, they'll be able to appeal that to the courts. So I don't think we'd be able to impose any settlements on the courts.
Thank you, Mr. Dent. Mr. McNeely?
Nothing further there, Mr. Chair, thank you. I look forward to further dialogue off the record to see if there's a remedy. Thank you.
Thank you, Mr. McNeely. I had a question. So the the current version of, or Bill 30, fines for offenses under the Act. Committee has noted that there's some issues of legislative clarity and certainty in doing so. An offense without a penalty is very hard for a court to interpret, and it's very rare you see this happening. Usually penalties are just repealed altogether, or fines and their associated penalties are gone, but it's odd to see one. And committee is concerned that if this was brought to a court, a judge would potentially not be able to hear the case because there's no clear guidance on what to do. So what is your perspective on the elimination of, or the repeal of fines under the Act? We assume it's due to the restorative nature, but it does create this challenge with the courts should it go there. Mr. Dent?
Right. It's not just the restorative. Even in jurisdictions where they don't use a restorative process, most don't use fines, because the nature of human rights legislation isn't intended to be punitive. The Commission has never, ever used that section. Most commissions in Canada don't have that sort of power or use that at all. We're not likely to develop a police force where we're going to be able to go out and charge people with those sorts of offenses. The process we have now, if there's a complaint, if it's referred, the adjudication panel has the power to impose a penalty. So, and that's the proper place for it, because it's only after adjudication that there's been somebody who's judged both sides of the story.
Thanks you for that clarification. So if these fines were, or if the offense provisions of the Act were eliminated altogether, that wouldn't dramatically alter the way the Commission's been using them insofar as they have not been using them. Would that be accurate, Mr. Dent?
Just quickly asked Ms. McLeod about that, and neither of us can see a reason for that being a problem.
Okay. Thank you for that. Mr. Simpson, did you have more? No? Okay. Oh, Mr. Nakamaiak.
Thank you, Mr. Chair. Thank you for the presentation. Sorry I walked in a bit late. And just listening to a conversation earlier and your conversation with Mr. McNeely, and you mentioned that the Inuville Settlement region is one of the region I represent at the legislature. And I'm just wondering what, you mentioned that you had spoken with Mr. Smith, the chair of the Inuville Regional Corporation. I'm just wondering what their concerns were and what your conversation was about on that. Thank you, Mr. Chair.
Mr. Dent?
Thank you. It was more an introductory meeting with Mr. Smith, just to talk about the commission, let him know about us. Basically, what we do, particularly with Indigenous organizations, is we offer ourselves as a resource, because, in fact, depending on where the complaint is. For instance, if a complaint has to do with an Aboriginal government, it isn't our commission that would deal with it. That would be the Canadian Commission. So it was basically helping or using it as the meeting as an opportunity to explain that when you're talking about companies that are owned by regional corporations, if they're incorporated in the Northwest Territories, then complaints that result inside that company would come to us, and other complaints would then go to the Canadian Commission. So it was more or less just saying, we're here, we can answer questions. It doesn't matter whether we're the ones that would take the complaint or not. We'll make sure you get to the right place. We just wanted to act as a resource.
Thank you, Mr. Dent. Mr. Nakamaiak?
No, thank you for that. I appreciate that. You know, coming from a land claims organization, we do a lot of the work that we do is directly with the federal government. Sometimes it's laterally with other Indigenous organizations, other Inuit groups that also deal with this. So it's good to see that you're looking out for local businesses. Thank you, Mr. Chair.
Thank you. Anything further from the committee? We were curious about the other, and we've talked about the gender prohibited grounds being, genetic discrimination. But on the criminal records side of it, we looked over that recommendation in your report, and we're trying to understand how it would work in practice if it was put into the Act. And it seemed like there would be a high burden on, let's say, an employer, a small business, who would have to make judgment calls over which records were acceptable, which ones weren't, and potentially making the wrong call might end them up in a human rights situation. And we're just wondering if you could help us understand what your perspective on how this grounds would work in a practical sense, and how you envision that right being added and supporting Northerners. Because the committee is not blind or deaf to this issue. It's a huge barrier to employment in certain circumstances, but we just like more clarity on how you think it will work in practice. Mr. Dent?
Yeah, we think it is a big issue in the Northwest Territories. There are a lot of people who are denied employment because of a mistake they've made in the past. And if it's a mistake that doesn't really relate to the job that's at hand, for instance, if somebody was an accountant and they had an accounting issue in a company, that shouldn't necessarily stop them from being a bus driver, I guess would be our position. And it would be much like accommodation is right now. Any accommodation is an individual assessment. So when an employee comes to an employer and says, I have this disability, I need an accommodation, there isn't a formula. There has to be a discussion. And each one of those times is a one-off circumstance. The employer and the employee are expected to have a discussion and try and reach some solution that accommodates the employee. The employer has an obligation to do that to the point of undue hardship.
Thank you. So if would it be that case where someone would come to the employer and say, look, I have a conviction for that's 20 years old, that's a non-violent offense, but it's a criminal conviction nonetheless. I don't think it's relevant, but I wanted to disclose it to you. And then the employer makes a decision, or is it more... is it something that happens afterwards where the employer finds out about a criminal conviction and there's job action taken, and then someone brings that complaint to the commission? I'm just wondering how is it something that's retroactive to an employer's action, or is it something that should be proactively disclosed and then accommodated? But Mr. Dent?
Well, it's always better to get things on the table up front. argue that that's the best way to conduct yourself is to get things out up front. So I don't know. We haven't. I can't tell you what they do elsewhere because I'm not sure they do it elsewhere. But I think that this is it's a big issue in the north. I think it's something we should take a look at, and it may take some time and some effort to get the wording right on it.
Could I add something?
Sure.
Yep, Ms. McLeod, go ahead.
So where we would see this is often employers will ask for a criminal records check. And when the criminal records check comes back, there's something there from, a long time ago. It has nothing to do with the job, but then they're immediately out of the running for that position because they failed the criminal record check. So where it's a problem here is that we know that, for example, Indigenous people often have more, overrepresented in the legal system. We also know that people with social condition issues, people who are poor, may not have the money or the opportunity to have asked for a pardon. So those people become they're vulnerable to being refused positions because they're criminal record checks, even though it's not related to the job and it was maybe a very long time ago. So that's where this kind of ground would be played out in a complaint process.
Okay. No, thank you for that clarity. It's very helpful. And to be clear, we're only talking about unrelated offenses, so it wouldn't apply to someone who has, an offense against a child and trying to work at a daycare. Yeah, okay. So I don't know if you can answer this, but, in some cases, you might have a job that requires a high security clearance. And in those cases, the records check isn't, it's not what you've done, but it's just the fact that you have it that impacts that. Would that be discrimination under this provision, or would that still be acceptable because of the demands of a high security clearance for police work or intelligence work? And that might be getting into the weeds. I'm just curious if these are things that have come up or that have been contemplated through your work in the commission. Ms. McLeod.
Thank you, Mr. Chair. Those kind of restrictions would be probably be taken care of in job descriptions. For example, in the same way that you ask for certain qualifications, you would identify the kinds of things that so if it is a sensitive position, if it's dealing with children, and there's an offense that is with a vulnerable population, that would be straightforward. It's identified in advance, and then that's a discretionary ability of the employer to just screen those people out because that is a related criminal conviction.
Thank you very much for that clarity. Anything further on Bill 30? Yes, Mr. Simpson.
Thank you. One of the amendments, I think, speaks to allowing the commission to carry forward a complaint in the public interest. And could you explain a little bit more about that? Is that if someone brings a complaint forward but then abandons it, but the commission feels that it should be carried on? Is it to address those types of issues? Thank you, Mr. Chair.
Mr. Dent?
But I think it would be more than just that. Right now, the Act allows the Commission to file a complaint. But what this does is it clarifies that we should be filing complaints that are in the public interest. You want to make sure that, and that ties into our the recommendation that we should focus more on systemic issues.
Mr. Simpson?
Thank you. Could the witness elaborate, perhaps, maybe give us an example that we can kind of sink our teeth into about what the result of this might be? Thank you, Mr. Chair.
Mr. Dent?
Well, for instance, let's say an individual filed a complaint that the transit system was charging rates that weren't fair to people who are disabled. They may get an individual settlement. The Commission could decide to pursue the municipality to make sure that that it wasn't just that one person who got a settlement, but that everybody got a settlement.
Mr. Simpson?
Thank you, I appreciate that. Nothing further.
Okay, thank you. That sounds familiar. Anything further? All right, well, thank you very much, Mr. Dent. If you have any closing comments, please. You may.
Thank you, Mr. Chairman, committee members. I do hope that we will see Bill 30 enacted in this session. I really think that getting the commission and the adjudication panel the ability to move more strongly into a restorative process, to get into more systemic issues, and to that's really important. So I'm hoping that this bill will get your approval and get moved forward. Thank you.
Thank you, Mr. Dent. Thank you, Ms. McLeod. And on behalf of the Standing Committee, thank you very much for your tireless work in advancing human rights in the Northwest Territories and serving in your respective roles in the Commission. It's very much appreciated by members of the Assembly, members of the public, and members of this committee. You're excused. Would anyone else from the general public like to present? Hearing none, do members agree that there are no further comments or presentation? Do members agree that our public presentation is concluded? Okay, thank you very much. On behalf of the committee, I would like to thank everyone who joined us today, and those of you watching online. As MLAs, it's a privilege to be here and to hear directly from you. We hope we provided some information on this bill and some insight into the Human Rights Commission's operations and why these changes have been requested. We will highlight the feedback we received during these meetings and from other public submissions. If you still have questions about the bill or would like to make a written submission, please email us or send us a letter. You can find our mailing information at www.assembly.gov.nt.ca. I will now adjourn this public meeting. Thank you very much.